Hello, everyone, and welcome to Uncivil Law. For today's case, a more technical issue. When does a case become final? This is the case of Tarsha Williams versus Taylor Seinbach Incorporated. This is a decision from the Fifth Circuit en banc. That's how serious we are about it. The entire Fifth Circuit decided to try to figure out whether or not a case is final or not, and goes into technical issues involving when you can appeal and when you can't. Because short lesson, if a case is final, you can appeal. If a case is not final, in other words, it's still ongoing, normally you can't appeal. There are certain exceptions for interlocutory appeals, which is what you call it when you appeal while a case is ongoing. But generally speaking, unless a case is final, you cannot appeal. So we have to figure out, when does that occur? That is the operative issue with this case. So let's figure out, was this case final or not? Can it be appealed or not? What's going on? Let's read on. When a plaintiff sues multiple defendants, counsel may need to take certain steps to ensure the plaintiff's right to appeal. That is because the courts of appeal have jurisdiction to review only certain types of district court decisions. Under 28 U.S.C. 1291, the courts of appeal may review only final decisions of the district courts. Under our precedent, there is no final decision if a plaintiff voluntarily dismisses a defendant without prejudice because the plaintiff is entitled to bring a later suit back on the same cause of action. And in suits against multiple defendants, there is no final decision as to one defendant until there's a final decision as to all defendants. All right, so first thing you need to know, you have sued a whole bunch of people, and the case is ongoing. At some point in this, you decide to drop against one of the parties. Now, you could dismiss it against that party with prejudice or without prejudice. With prejudice means that's final. It's prejudiced to future action. You have made a final decision. So if you dismiss with prejudice, that cause of action is dead. Most attorneys, of course, want to keep their options open for as long as possible. Attorneys like options. So attorneys, generally speaking, if they can, will dismiss without prejudice. Because why not? If I can, why not do so? I can bring the case either here or in a different court, wherever. But I have the option to bring it somewhere, again, in the future. Maybe I brought this in federal court, I want to bring it in state court, or the other way around. Maybe I brought this in one state, I want to bring it in a different state, whatever. But if I dismiss it with prejudice, I can't do any of those things. I can't file a different court, can't file a different state, can't file anywhere. The case is dead. If I file without prejudice, I have options. Attorneys like options. That's rule number one. And if you have multiple defendants, and you dismiss against one of them, the case is not final against that person. Because you could bring it back. So it's not final because you could bring it back. So you haven't reached a final decision. So if you have a whole bunch of defendants and you dismiss one of them without prejudice, it is not final as to that particular defendant because you could bring it back. So far, so good. Let's read on. A potential complication arises when a case implicates both of these principles at the same time. That is, when a plaintiff sues two or more defendants and voluntarily dismisses one of the defendants without prejudice while litigating against the other defendants to conclusion. So you have multiple defendants, you have dismissed at least one of them is dismissed without prejudice, and you have a whole bunch and you want to litigate the rest. So now what? Now, some have expressed concern the plaintiff may fall into a finality trap, unable to appeal a final decision despite having lost to the second defendant. Yeah, so you can't appeal unless it's final, and so you have run into a trap. You have dismissed one person without prejudice. You have all the other stuff that happens. You get to the end of the case. You lose against some of them, and you want to appeal. The court says you can't. You can't appeal because the case isn't final. But it's final as to these defendants. But the case isn't final because you still have a defendant out there with a cause of action that's open because they were dismissed without prejudice. You could bring it back. And because you could bring it back, the case isn't final. Even though it's final as to some defendants, the case isn't done. So you have to go resolve that before you can appeal. So that can be really, really tedious for very obvious reasons. Because if you dismissed without prejudice, for example, because you want to go file in a different court, you have a different cause of action, you want to go file in a different court, as long as you can bring it back here, this case isn't finished. So you have to go ramble through whatever court process that is until that finishes, then maybe you can appeal. So that's a problem. That's what they call the finality trap. It's not final unless it's final to everybody. So, yeah. The established rules of civil procedure provide many tools to avoid this trap. They include amendment of the complaint to remove claims or parties under the Federal Rules of Civil Procedure. So you can remove a party under one rule. You can sever the parties under Rule 21, and you can enter a partial final judgment under Rule 54. And you can also voluntarily dismiss with prejudice. So you have a couple options to help avoid this trap, but you didn't do that here. $5 from Catastrophe. Thank you for the super chats. It is always super appreciated. I'm in California. I'm very sad for you. Please move out. With how much debt, with trillions in unfunded liabilities, what happens if we default? DC pays. Any historical precedent? Well, at the moment, there is no remedy for that. The states are required to have a balanced budget. If they default, then they, at least under the current law, they can't declare bankruptcy. So they would essentially just have a huge liability pool with no way to discharge that, and they would have to be essentially the same position as someone who has persistent legal debt. So in the same way you can't get bankruptcy personally for a legal judgment. So if I sue you and I win and I obtain a judgment against you for whatever amount of money, bankruptcy doesn't discharge that. That's a legal obligation that you have to me. And, you go through bankruptcy, a legal process to undermine a different legal process would be a collateral attack. You can't do collateral attacks. If you have a final judgment from a court, you can't collateral attack. So if you try to do a bankruptcy, that's essentially a collateral attack. You can't do that. So you have to keep paying me forever. And same thing with student loan debt. You can't get out of that. So it would be essentially the same thing as that kind of debt. The state would just be on the hook forever for it, and they would have to pay indefinitely through whatever interest rates and whatever else. And yeah, Mitch McConnell had suggested amending the rules to allow the states to declare bankruptcy, and the left went completely nuts. Cuomo and Newsom both went completely nuts and said, "This is horrible. They want to kill our Social Security." Historically, the U.S. government has bailed the states out. I don't know if they've ever left a state hanging, but historically, D.C. has bailed them out. But they don't have to. They don't have to bail them out. They could just leave you twisting in the wind, which personally I think would be hilarious. Let them choke on their own massive debt. It's like, you're the guys who created this system. Now you choke on it. So I don't really have a strong opinion on whether states should be able to declare bankruptcy or not. I don't know. I don't even know how that would work. How do you restructure that debt? I don't know. But yeah, I don't have a strong opinion on that. But as far as I'm concerned, DC should not bail them out, and they should choke on it. They're the ones who want to create all these wonderful programs. Let them pay for it. So let's learn a little bit about the facts of this particular case. The plaintiffs sued 24 defendants after their father died of mesothelioma, which I know from one too many lawyer ads is a lung disease. Great. After protracted litigation from a multi-district litigation court, and we've talked a little bit about that before, when you sue a whole bunch of people in a whole bunch of places, there's a multi-district litigation court that figures out where this is supposed to go. Several defendants obtained a summary judgment. The Williamses subsequently moved to dismiss the remaining defendants, including CSR and the Godfrey Company, pursuant to the rules. The district court granted the dismissal, but didn't state with or without prejudice. Fair enough. On appeal, this court held that CSR, Environmental Abatement Services, and Godfrey were dismissed without prejudice. Accordingly, we dismissed for want of a final judgment. So there were a couple people dismissed. You got them dismissed. They didn't say with or without prejudice. We say it's without, which is typically what you would expect. If it's with prejudice, you typically say it because they want to be clear. So without makes total sense, and that's why it's a problem. In response to the initial dismissal, the Williamses sought and obtained a partial final judgment under Rule 54B to the various defendants, including Seinbach and McCarty, and appealed again. A panel of this court held the district court lacked the power to enter a partial final judgment under Rule 54B and therefore dismissed once again for want of a final decision. So you couldn't do what you did, therefore it's still not final. Okay. We subsequently granted a rehearing en banc. We now conclude that Rule 54B authorized the district court to enter a partial final judgment following dismissal of remaining defendants, and that the appeal may therefore proceed. So this is what we're here for, trying to figure out whether or not we can appeal or not. So the appeal court said no twice. They said no because there's still some people left with some cases open. So they went back and tried to obtain a partial summary judgment. Okay, we have a partial summary judgment from the district court. The Court of Appeals said no, you don't. The district court couldn't do that. They couldn't do that. You still don't have an appeal. So they appealed from the appellate court to the appellate court, to the en banc. And the en banc said, actually, no, you do have a cause of action. We can finally hear your appeal. This is final enough. We are saying it's final. Let's try to figure out why. This case involves the intersection of two different federal rules of civil procedure, Rule 41 and Rule 54. We addressed 41 briefly, but turning to 54. Rule 41 allows plaintiffs to voluntarily dismiss an action. One could, as the dissent does, plausibly construe an action to refer only to the entire case and not to individual defendants. But our circuit precedent interprets action to cover the individual defendants, thus allowing plaintiffs, like the Williams, to use this rule to dismiss individual defendants. So there is a rule that allows you to voluntarily dismiss somebody. It allows you to dismiss an action. What is an action? What is an action? Is the entire case an action? Or is each separate cause an action? Right? Lawyers typically use the phrase cause of action. You've seen them before where they're listed. Count 1, count 2, count 3, count 4. That's how lawyers typically think. They think about them causes of action. And they would think about them as it applies to each particular defendant. Because you could have causes of actions that would apply to some and not to others in a common case. That they have enough things in common that you're joining the lawsuits, but not all causes of action necessarily apply to all defendants. So that makes sense. So the idea, at least to a lawyer, at least to me, the idea that you could dismiss an action relating to a defendant without dismissing the entire case makes sense. Because I could have not brought that in the first place. And when I was drafting it in square one, when I was drafting my complaint in square one, I could have just not brought the complaint at all against that defendant or that cause of action. I could have just not included them. This is part of a drafting decision. There might be reasons not to include someone, even if you could. So I could have made the decision in the first instance not to include that defendant or only include them as the certain counts and other counts. I can do whatever the heck I want. So if I can do whatever I want on the front end, then why shouldn't I be able to do whatever I want on the back end? Why shouldn't I be able to dismiss a particular cause as to a particular defendant, or dismiss a particular defendant, or do whatever I could? I'm just undoing exactly what I could have done in the first place. Seems reasonable. The majority says it's reasonable. Apparently the minority says it's not reasonable. By an action, the rules mean the entire thing, which again seems a little odd to the way I would think about it. I think the majority is probably right and for the best. You want to have that sort of granularity, it appears to me. Having determined that we can do what we want to do in Rule 41, we now turn to the issue of the validity and the appealability of the final judgments entered by the district court. Can we do that? Congress has empowered the Supreme Court to clarify when a decision qualifies as final for appellate review purposes and to expand the list of orders appealable on an interlocutory or while the trial is ongoing basis. So you can appeal when it's final and sometimes while it's not final. And the Congress has said the Supreme Court can clarify those rules. Excellent. This procedure Congress ordered for the changes, however, is not by court decision, but by rulemaking. So this is a situation where the court acts as a rulemaking authority, which makes perfect sense. The idea that courts can determine their own rules and determine process within their own rules, they are a body that has the ability to do that. So they create rules of procedure. The civil rules of procedure, appellate rules of procedure, all that good stuff. The statutory guidelines is done essentially through a rulemaking process. It's a little bit different in terms of how it's done technically because it doesn't come with the rulemaking process under the Administrative Procedures Act, because the Administrative Procedures Act, as the name implies, deals with administrative, which is to say the executive. So you don't have to go through the same kind of notice and comment period. It's not held under Chevron deference, thank the Lord, when it's finally adopted, because it's not being done by an administrative agency. But the Supreme Court can indeed create rules to govern the lower courts. It's one of their roles as a supervisory court. So they do it through rulemaking. And the court is pointing out here that what we do is we don't augment this through rulemaking or augment this through decision making. We do it through rulemaking. So this is a little interesting quirk here because essentially as to this aspect, The court is essentially behaving as a civil law system, not as a common law system, which is really interesting little tweak there. Because when the Supreme Court is adopting these rules, the court is here saying, well, what guides is the rules, not the court decisions. Therefore, as to this rule aspect, we're essentially a civil law system because we don't really care about the precedent, we care about the rule. It's a little tweak there, at least the way that they're describing it, but that's how they characterize it. So a very interesting little nuanced touch there. Gary asked, how many times can you appeal a Supreme Court decision? You can't appeal it, but you can ask for reconsideration. I can't think of a time they've ever granted reconsideration. Ever. Off the top of my head. Lawyers do it routinely, and they routinely deny it, but you can't ask for reconsideration. Why would they? You know, you've just gotten to the end of the case. They've just issued a decision, like, we want reconsideration. And you're like, maybe we should take another crack at that. Don't see that happening, but technically it's allowed for in the rules. So there's that. Start rebutting the legal eagle. Well, I did do the one on I did the one on Captain Marvel, where I rebuffed the crap out of him. To begin, it is important to understand what the Williamses want. Appellate review of the district court's entry of summary judgment as to certain defendants without litigating all the claims they brought against all the defendants they sued. So they would like review of the summary judgment as to some of the issues, but not all the issues. There are many ways this could have been achieved under the current rule precedent without running afoul of the final judgment rule. They could have dismissed the remaining defendants with prejudice. So if you had taken away that would work. They could have amended their complaint to excise any remaining claims or parties under Rule 15. They could have requested severance of certain parties under Rule 21. So maybe you could have severed the cases so they were different cases. Or they could have done what they did here, seek a partial final judgment under the rules. Rule 54B thus sets forward a governing framework for determining finality in a suit against multiple defendants. Of course, once a district court has decided all claims against all parties, the decision is final. By contrast, any order that resolves the rights and liabilities of fewer than all the parties is not final, because any such order may be revised at any time before final judgment. So what the Court of Appeals is saying there is that as long as it's not final as to everybody. So again, technically speaking, and it does occasionally happen in district courts, it does occasionally happen where a district court will get to the end and then say, no, I've actually reconsidered and I want to do something else, as something else is happening along the time. So trial courts from time to time, more frequently than you might expect, but still rarely, but it does happen enough to be noted, that they reverse themselves. They say, I took another look at this case law, I took another look at this thing, I reconsidered the issue, I reconsidered whatever, I'm going to amend my ruling, I'm going to amend my decision, and I'm even going to amend my judgment in a case. Now, once the case is final, the district court can't do that. They can't take it back once it's final. But if it's final as to somebody, but not final to everybody, it's not final as to everybody. So even though the court said, okay, final decision, this is my decision, you're done. As long as there's something about it pending, the court can say, actually, now that I think about it, you're not done after all. I've changed my mind because the case is still alive. So that's one of the reasons why they don't like these appeals, as to some people or not other people, because, again, technically speaking, it's still within the district court's provenance. The district court could change its mind. It could reverse the judgment. It can do whatever it wants as long as the case is still pending. Well, not whatever it wants. It has to be consistent with law. But it can change its mind. It can change things. It can say, actually, as I've considered this more, we need to do something different. And so that's one of the things that they're mentioning. Rule 54B sets forward a straightforward path that Williams dutifully followed. The only wrinkle is where a district court can enter partial final judgment when a plaintiff first litigates the case to conclusion as to various defendants and then voluntarily dismisses all the remaining defendants as they did here. So, can I get a partially summary judgment because I have voluntarily dismissed all the remaining people? So I have a summary judgment as to everyone who's left. All I have, and I have some people who are not left. Can I appeal that? Can I do that, please? Let's find out. The prior case of Swope is correct, and we apply it here. Rule 54B authorizes district courts to direct entry of final judgments as to one or more, but fewer than all claims or parties. So you can submit it to one or more, but fewer than all if you're so inclined. And voluntary dismissal of some defendants under Rule 41A at the end of the case does not alter this authority in any way. Why would it? A dismissed claim remains part of the case, absent amendment of the complaint under Rule 15, to strike them completely, to sever them, all that good stuff we discussed. And this is so regardless of whether the Rule 41 dismissal occurs. Likewise, the fully litigated claims, such as the partial summary judgments that Williams hoped to appeal, naturally remain pending before the court as well. So there's no reason why a district court cannot enter a partial final judgment with any remaining defendants who are voluntarily dismissed at the end of the case in Rule 41. As a result, the Seventh Circuit concluded the plaintiff must take some additional step, such as entry of a partial final judgment under the rule in order to appeal any other claim. That is because Rule 54 authorizes the district court to make immediately appealable a judgment that disposes with finality one or more, not all the claims, even though other claims remain pending in the district court, so the suit as a whole has not been disposed of as a whole. So you have to take some additional step to do that, according at least to the Seventh Circuit's panel decision. In other words, text of Rule 54 identifies the problem that it's attempting to solve, adjudication as to only some parties or some claims that does not end the action and thus is not a final judgment, and then provides a solution. District courts may enter a partial final judgment to facilitate appeal. So there is a way to solve this problem. The district court can, at least as far as we're learning, they could have entered a final judgment and say, no, I'm going to remove my authority as to this. So I'm going to make this part of it final. And the rule seems to allow for that. So there's a mechanism for the district court to say, this is actually a final judgment, at least according to that rule. How does that interact with our current situation? Plaintiffs have many options to preserve their rights to appeal under these circumstances, and the Williams have properly exercised one of those options here. As a result, we need not answer certain questions that have been raised in this proceeding. For example, some have argued that voluntary dismissal of a defendant or claim without prejudice is a final decision, and thus should not deprive this court of appellate jurisdiction, and we should revisit our case law to the contrary. Others have responded that voluntary dismissal without prejudice is not a final decision because dismissal decides nothing. The plaintiff can refile, and at a minimum, stare decisis commands respect for understanding because it's not demonstrably erroneous. Our decision today avoids the need to resolve these issues. The vortex of the finality trap lurks whenever a plaintiff sues a basket of defendants, but established rules of civil procedure offer various tools for avoiding the trap. The Williams used one of these tools, a partial final judgment. As a result, we have jurisdiction to hear these particular appeals. We therefore return the case to the panel for a decision on the merits. So that is the end of the case of Teresa Williams versus Taylor Seinbach Incorporated. In this case, from the en banc Fifth Circuit Court of Appeals, we learned quite a lot about what makes a case final and what doesn't. We learned that typically when you have dismissed one party without prejudice, even if you get a result as to everyone else, it is not final because you could have brought that claim of action back. But at least according to the en banc, there is a way to solve that problem. Rule 54 allows you to get not a summary judgment, but a final judgment, and allows you to make it final as to them so that it cannot be taken back and you can appeal. So the Fifth Circuit returns the case effectively to itself, to the panel decision, for a merits on the appellate issues. So they'll go back and actually decide the appeal as to whether or not a party should have won or a party should have lost. And presumably, if the Court of Appeals reverses with the case still quasi-pending in the district court, then there will be no loss of time because the court's already hearing the issues anyway. So this is a very bizarre, very technical case dealing with procedure on when courts can hear what cases, and that's the end of our current coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.